Center for Transnational Law. We'd like to thank you for attending our webinar, Human Rights in Americas, Challenges, Obstacles, and Opportunities. We're very excited for this event and look forward to hearing from our honorary guests. Before we start, we would like to encourage everyone to follow us on Twitter at Rutgers-CTL. And we're also excited to announce the launch of our new website, which can be found at ctl.rutgers.edu. On behalf of the center, we would like to thank our co-sponsors, the American Society of International Law, Latin American Interest Group, and the Rutgers-Newark Human Rights Working Group. Also, just if you look at the bottom of your Zoom panel, you'll see a question and answer function. During the last 20 minutes of this lecture, we'll open up the meeting for questions, but feel free to submit your questions throughout the lecture series and we'll bring them up at the end. And with that, I'll hand it off to Professor Contesse.
Thank you, Corey. Thank you, everyone, for your patience. We're very, very sorry. We're dealing with some technological glitches. We're not sure where they're coming from, but we should just get started. We are very pleased to have Flávia Piovesan as our speaker today. Flávia is a Brazilian national. She's a good friend. She's a human rights lawyer who is a member of the Inter-American Commission on Human Rights. And as a member of the Inter-American Commission, she is also the country rapporteur for the United States. She has extensive experience working in human rights law, both in Brazil and around the world. She has been a visiting fellow and professor in a number of institutions. And most recently, just 3 weeks ago, the Inter-American Commission on Human Rights, which is based in Washington, D.C., held a hearing on structural racism in the United States. And so we are very pleased to have you, Flávia, to talk about the challenges and the obstacles of human rights in the Americas, which includes South America, Central America, and certainly North America. And we're also very pleased to have you here at the Center for Transnational Law. As Corey explained, Flávia will present for about 20 to 25 minutes, and you can use the chat function to ask questions at the end of the session. Flávia, the floor is yours.
My dearest friend, Jorge, thank you so much for such a kind invitation. Now I feel relieved that I'm back with my voice, with my image. Sorry, please receive millions of apologies for this technical obstacle, but we overcame. And I feel very happy to discuss with you, to share with you this topic, human rights in the Americas, challenges, obstacles, and opportunities. So once again, I'd like to express my deep gratitude, my recognition for the wonderful work you have been doing, and my enthusiasm to debate this hot topic. And I'd like to address this topic considering my experience as a vice president of the Inter-American Commission on Human Rights, addressing three central questions. So the first question I would call the why question. Why do we need an inter-American system? The second question would be the how. How has the Inter-American Commission developed its transformative mandate? And what are the limits and potentialities of this transformative mandate facing the challenges, the obstacles, and opportunities of human rights in the Americas? So I'd start with the why question. Why do we need an inter-American system? And this question leads to our specific, and I'd say peculiar, regional context characterized by three structural challenges. And I'd say that the pandemic has even aggravated and greatly exacerbated those three challenges. First, I'd say that we live in the most unequal geography of the world. Latin America displays the highest inequality levels in the world. 6 of 20 most unequal countries in the world are in Latin America. Today, 30% of the population in the region lives in poverty. And CEPAL even estimates that the number will increase to 34.7%, and 11% live in extreme poverty. So the pandemic reveals that there are the ones who die because they are too poor to stay alive. such as the 25% of the population who lacks access to drinking water, sanitation, or the 53% of the population who works in the informal sector and largely relies on their daily sales to survive. As my dearest friend, Professor Jorge Contesse, mentioned, I have the honor to serve as country rapporteur to the US, to Bolivia, Panama, and Jamaica. For example, in Bolivia, 80% of the population work in the informal sector. The second structural challenge has to do with historic pattern of discrimination. What we see in the region, and our mandate embraces 35 countries from north part of America's Central, Caribbean, and Southern part. What we can conclude is that the Afro-descendant population accounts approximately for 25% of the population. Regarding the indigenous peoples, it is estimated that it accounts for 10%. Social indicators demonstrate a systematic, historical, structural pattern of discrimination and exclusion and violence affecting Afro-descendant and indigenous peoples in the region, with women and children subjected to overlapping discrimination. For us at the Commission, intersectionality is a key perspective. So, as quoting here Bachelet, we had a meeting with the Commission and Bachelet weeks ago, and she emphasized the virus is not discriminatory, but its impact is. For example, in my country, in Brazil, Afro-descendants have much higher lethality regarding the virus. Indigenous communities here face a critical vulnerability situation. In the US, Afro-descendants are 4 times as likely to die of the disease as white. So they have hospitalized for COVID-19 at 4 times the rate of white people. In terms of an employment rate, if you consider the Afro-Americans, is nearly double of the white Americans. So we have the second structural challenge. And we have a third structural challenge, which has to do with the rule of law, or I'd say the institutional deficits, the democratic deficits in the region. Last year, Latino Barometer survey on support for democracy found that just 48% of interviews, less than half, consider democracy to be preferable to any other form of government. So what we see, according even to Pew Research Center, is that non-democratic alternatives would have a rate of endorsement of 35% in Brazil, 25% in Mexico, 18% in Argentina. Over half of the countries in the region are placed in the bottom half of the most governance indicators, including Transparency International Corruption Perception Index and Rule of Law Index. And we have another problem. We just adopted at the Commission a thematic report about corruption and human rights. And in March 2018, we were having sessions in Colombia when we adopted resolution number 1, 2018, about corruption and human rights. Seeing corruption from a human rights approach, understanding corruption as a human rights violation per se, which violates other rights. And according to Transparency International, COVID-19 is a perfect storm for the corrupt. So I would say that we are facing the harder test for our democracy and rule of law in the regions, as what we have is the empowerment of the executive branch and the army. And then, of course, there is always the risk of abuse of the arbitrary use of power in a very complex and regional context. So I also would like to highlight, as a country rapporteur for the US, that we had a week ago, we just finalized our period of sessions. The next one will be in December. We have more than 60 years of history in the human rights system. In the Inter-American Commission celebrated its 60th anniversary last year. And the first virtual session that we had was in July. But we were afraid of including public hearings. We just kept our sessions dealing with the most complex cases, merit reports, admissibility reports, precautionary measures, having also moments with the civil society, Inter-American Civil Society and the states. But this time, 2 weeks ago, we had 30 public hearings, and 2 were really powerful, involving the US. One about freedom of expression and journalism in the context of protests in the US, and the other about structural racism and police brutality in the US. I just like to highlight that yesterday we made a statement about what happened in Philadelphia, condemning the disproportionate use of force by police agents that shot dead Walter Wallace, African American, in Philadelphia, and urging the United States of America to investigate, prosecute, and sanction those responsible for acts of police brutality and racial discrimination against African Americans. Also, stressing the need to grant comprehensive and satisfactory reparations to victims and to implement structural police reform. In the beginning of August, we also adopt a press release calling the US to implement structural reforms in the institutional systems of security and justice to counter historical racial discrimination and institutional racism. And we here presented some data, important data, why Afro-descendant persons constitute 12% of the total national population. They represent 33% of the prison population. African-American people in the US earn 60% less income compared to those of families of other ethnic racial origin. And we are really concerned about the disproportional use of force and brutality. We claim here for police reform and affirmative action and training curricula for police. So it's interesting to share with you that we have a new agenda concerning the US. We have an agenda which deals with police brutality. We have an agenda now which deals more and more with sanitation, problems of access to sanitation, migration. This weekend, we were debating this with a lot of concern, the situation of 545 migrant children and teenagers who have not been returned to their families. So this, we are always from this intersectionality approach, bringing forces together with different thematic reportership to deal with those very serious situations. So we received as well a letter from the Congress of the US, October 23rd, about grave situation of human rights abuse by the United States Department of Homeland Security concerning sexual abuse, gender-based violence against detained immigrants, complaining of sexual abuse. So what we have, I remember when I started the mandate, the agenda concerning human rights violations in the US was much concentrated on death penalty case, still, gun control, still, immigration, but the situation is quite dramatic right now. But now, more and more, as we know, police abuse, police brutality, racism, structural racism, and even for me, for my surprise, to be honest, the issue of sanitation. When we had a meeting with civil society, this was something really emphasized by the voices of different social movements in the US. So now I'd like to address my second question. How has the Inter-American Commission developed its transformative mandate? We used to say at the Commission that our mandate is to protect and to promote human rights in the region, according to Article 41 of the American Convention, but also our ambition is to contribute to transform realities, or I would say social change, always acting with independence, impartiality, and being guided by the Inter-American standards, by the Inter-American Corpus Juris. The victim-centric approach inspires our work, which deals with human suffering and the need to provide effective remedies to safeguard human dignity and to prevent human suffering, always paying special attention to persons and groups who face special vulnerabilities. I'd say that our mandate has an hybrid nature, almost judicial but also political. We have a fascinating toolbox comprising 7 different tools and mechanisms, case system, redressing human rights violation, with the adoption of this Institute of Comprehensive Reparations. We do believe that structural human rights violations have structural causes, and our transformative mandate needs to have an impact on those causes. So here, our response to human rights violations involves not just compensatory measures to pay an economic compensation for the victim, but also the duty to investigate, process, and punish perpetrators, adopting due diligence, and to adopt structural changes, such as new laws, legal reform, legal public policy based on guarantees of non-repetition. I'd say that this is a unique role played by the Inter-American system, advancing structural reforms. Last December, I made a proposal to my colleagues, and I was very pleased to have the approval of the creation of an observatory of impact to measure the transformative impact of our work, aiming to identify and systematize the structural changes fomented by the Inter-American human rights system. I remember for 2 years I served in my country here as a president of a national commission against forced labor. And I'm always emphasizing that the national plan and the national commission against forced labor in Brazil, they exist as a response to the recommendations of the Inter-American Commission on Human Rights. Our law regarding violence against women as well is a response to a recommendation of the Commission. The second tool has to do with precautionary measures in the case of grave, urgent human rights violations and irreparable damage. I'd say that is an effective tool to save lives. Public hearings, I'd like to invite you to follow some of the public hearings. I'd say that they reflect the key human rights tensions and topics of our agenda, such as the US. I mentioned Bolivia. We had 2 public hearings, very intense hearings about the general situation of human rights in Bolivia, judicial independence in Bolivia. I have the honor to serve as an LGBTI right rapporteur, and we had also public hearings about LGBTI rights in the region, in the Caribbean, same-sex marriage in Panama. We had public hearings about migrants, about disappearance in Mexico, about indigenous rights in Colombia. So if one wants to have a map of the key questions and key topics and tensions in the regions, I would suggest to follow a little bit the agenda of the public hearings. Finally, we have friendly settlement agreements with high level of compliance due to the active involvement of different actors. We have thematic reports. I remember last November, I was honored to present with my colleague, the rapporteur for economic, social, and cultural rights and environmental rights, a report on business and human rights inter-American standards. We just adopt weeks ago a conceptual note about a new report about cultural change and LGBTI rights. We adopt another report about trans persons and access of social rights. So we have 13 thematic rapporteurships. We also have country rapporteurships. We have 35 countries. So, for example, President Maduro denied our entrance in Venezuela this year. We were not able to go to Venezuela, but the Commission prepared a report about the situation of human rights in Nicaragua, in Honduras. We are preparing a report about our in loco investigation in Chile this year in January. Last year, I led a mission to Haiti in December. We are preparing a report. El Salvador in November. Ecuador also in November. Of course, the in loco investigation right now with the COVID-19 is standby. So I'd like to share the balance of our 60th anniversary, point out 98 in loco visits, the adoption of more than 70 country reports, the adoption of more than 80 thematic reports, celebration of more than 170 period of working sessions, more than 2,400 public hearings, more than 2,200 press release. What I would say is that our role is to contribute in establishing human rights standards, compensating national deficits, and I'd say fomenting a new dynamic of power among social actors. It's also important to recognize that all the transformative impact of the Inter-American Commission results, above all, from the vital role played by the civil society, which gives oxygen, which is the driving force of the system in its struggle for rights and justice. And I'd like to conclude the second question saying that the system saved and has saved many lives. It has fostered the destabilization of dictatorial regimes, demanded justice and end of impunity in democratic transitions, and now demand the strengthening of democratic institutions, combating human rights violations, and protecting the most vulnerable groups. And we also have a new agenda like digital rights, digital privacy, hate speech online, corruption and human rights, business and human rights. And I'd like to finalize 3 minutes, finally. What are the limits and potentialities of this transformative mandate facing the challenge of COVID-19, which are the obstacles and opportunities? So I'd like to end up just here sharing with you our work in reacting, in dealing with COVID-19 and how the impact in the human rights agenda. In March, we adopt a kind of task force, a special unit to monitor the response of each of 35 countries to COVID-19 based on human rights approach. It was so-called a special unit, rapid and integrated response coordinated unit. In April, probably we were the first international body who adopted resolution number 1, 2020 about pandemic and human rights in the Americas, facing those 3 challenges that I mentioned: the deep inequality with the language of social, economic, cultural, and environmental rights, endorsing the state international legal obligations in protecting right to health, water, adequate food, also endorsing science as a component for the public policies. Concerning historical pardon of discrimination, our language here in those recommendations, a package of 86 recommendations, facing historical discrimination, we strengthen the language of equality and non-discrimination, giving special attention to the protection of vulnerable groups, such as LGBTI rights, elderly, migrants, children, adolescents, women. And once again, our language is always to endorse the international state obligations, in this case, in providing reinforced protection to those vulnerable groups. And finally, and rule of law. Here, we emphasize that any and all restrictions and limitations on human rights to protect health in the context of COVID-19 shall comply with the standards of international human rights law. In particular, the principles of legality, proportionality, the suspension and restriction of rights shall be also temporary. And I'd like to mention that 12 states from the 35 notified the Department of International Law of OAS about Article 27, clarifying the level, the scope of the restriction of rights in the name of pandemic. So we are monitoring those responses with a number of cases of abuse, abusing and violating freedom of expression, freedom of speech, among others. I'd say that this is a global challenge. I'd say that in the world, 94 states in the world adopted policies and response restricting rights. And I'd just like to conclude emphasizing our mandate to protect, to promote human rights in the most unequal, the most violent geography in the world. Thank you so much.
Thank you, Flavia, for those remarks. So you can use the Q&A function to ask questions, but I believe you may also raise your hand and pose your questions directly using your microphone. So please feel free to do that. There are two questions that participants have raised. One is, in general, they're asking what issue are you most passionate about? So that's for you to think, Flavia. And there's another one from a judge in Brazil who asked about your thoughts on how do you think could bring a solution to prison condition cases in Latin America and in Brazil. So the issue of prison condition, which of course is a major topic in the Inter-American human rights system. And if I may, I would like to ask you, Flavia, to reflect on there are challenges which are, I would say, structural, as you have also explained, that concern the situation in the region. This is a very unequal region. It's a region where we have a number of human rights problems. And one thing in particular that I have been following in the past years is a sort of process of attacks and pushbacks against the Inter-American human rights organs, both the Commission, but also the Inter-American Court of Human Rights. So it's interesting to see, for example, that in 2017, the members of the United States delegation simply did not show up for the hearings before the Commission, which is something that, in my understanding, had not happened before. But now we see members, representatives from the US government, same administration, who are actually engaging with the Commission. So 3 weeks ago, when you were holding this hearing on structural racism, there were members of the US government providing explanations, addressing some of the questions that the Commission has posed. And so I'd like to know a little bit more of how the Commission understands that whether or not you feel that you need to adjust some of your work, and if so, how, in the present context in which countries are being, I would say, more aggressive in pushing back against the Commission. Last year, 5 South American governments sent an unexpected letter to the Commission saying, you guys need to step away a little bit, you need to give a little more deference to states. And so maybe in general, you may reflect on how international human rights bodies can actually engage with states when those states are less willing to participate, to respond to your request for information, and how is it that you see the work of the Commission moving forward in this context of, I would say, enhanced resistance and pushback by different actors, particularly by states.
Thank you so much. I'd like to start with your thoughtful question, my dearest friend. And I would react in three directions. First of all, it's a very fascinating mandate to serve at the Inter-American Commission on Human Rights. Because on one hand, the driving force is the victim. So I'd like to endorse that we adopt the victim-centric approach. So we are there, our mandate exists and justifies, and our legitimacy is to safeguard human dignity and to prevent human suffering. So on one hand, we look at civil society, victims, social movements. On the other hand, we look at the states. So we are always, I'd say, those are the actors that we interacted a lot, all the time. For example, in every period of session, we always have meetings with civil society. Like this time, we had three meetings with civil society, but we had one day dedicated to state dialogue. So we always divide in 4 groups: North America, Caribbean, Central America, and South America. So 2 hours, from 2 to 3 hours to each group. So the whole day, more than 10 hours listening and this thing. Why? Because this is very important for our effectiveness. That's the, I think that's the balance that we need to achieve, to act with independence, to act according to inter-American standards. So I myself, I love that passage of Ronald Dworkin, who see the legal interpretation as a romance, that you are adding chapters. So I myself, I look at an institution, and I'm very institutional. I look at an institution that pre-exists like 60 years. I'm there for 4. What would be my contribution to this institutional history? So that's the challenge, I'd say, of the mandate, is to provide an effective remedy, integral, I'd say, comprehensive reparations. And of course, we need to keep a constructive dialogue with states. Because, as you know, as a great professor, according to our comprehensive reparation system, our recommendations will not be complied with next Monday. Because if we demand not just the payment of a compensation, if we demand to change the law, to adopt new public policies, and so on and so forth, this demands a process of implementation. So that's important, to monitor this process, to do the follow-up, to do working meetings, a lot of working meetings, to hear here, to hear there, and to have an agenda with goals, with targets, concrete and really sizable targets. That's my view, our view right now. We are investing a lot in the monitoring mechanism, in a unity which could follow up our decisions. My second reaction, that's an indicator. When we go to our public hearings, empty chairs, that's a very bad indicator. So public hearings against Cuba, public hearings against Nicaragua, for example, we have no state representatives. That is too bad. They are not playing the game. So one indicator is to have state representatives, because we have a horizontal dialogue. We have the victims, civil society, state representatives. We are coordinating this debate. And it's very touching to see, for example, in the case of Mexico, in the case of forced disappearance at Ayotzinapa or feminicide, the family of the victims, for the first time, they look into the eyes of the authorities. They have this opportunity, and we have to potentialize this opportunity to bring, some steps in building up a solution, in trying to protect rights. So I think this is an indicator, if the state's there, if it's not, and who is there representing the state. This is another indicator. For example, states like Argentina and Mexico, we see high-level representation, ministers of justice, minister of foreign affairs. Sometimes we have diplomats who are not senior, who are representing the state. So there are a number of indicators to measure, I'd say, the engagement of the state into the inter-American system. But of course, if there is an attack from the state, it's because we are doing our job. That's my perception. That's an indicator that we are doing our job. We have to always, I'd say, always dialogue and rebuild trustness. And it's not that easy. I can spend hours sharing some experience in this field. The second question concerning prisoners. I'd like to say hi to my friend from Brazil, from Ajures, which is Association of Judges in the southern part of Brazil. And I'd like to mention our recommendation number 45 concerning persons deprived of liberty. I'm again mentioned here the resolution 1/2020 about pandemic and human rights in the Americas. And what we call the states to take measures to address overcrowding in prisons, including reassessing cases of preventive detention in order to identify those whose status may be converted to that of an alternative to incarceration, prioritizing people with greater health risks, such as women who are pregnant, elderly. So we also recognize the effort of the National Council of Justice in Brazil adopting this recommendation. And I'm proud to see even our Supreme Court. We saw some votes from the Supreme Court of Brazil based on some dishes based on this recommendation. And I think that's the problem in the Americas. The average of preventive detention in the region is 40%. It's a lot. In Haiti, is 70%. So there is this culture that I think that's a cultural problem. We have to change the culture of, depriving people from liberty in any case. We have to rethink in a conceptual basis the system. So, and I would say that trying to find out best practice, that's a very, I think, fruitful work that we do, as our mandate involves 35 countries. So we have 35 different experiences. For example, in the pandemic, we organize webinars about public policies, best practice, and not good practices as well. So I think we have to rethink deeply, and also I would say considering intersectionality. And the Commission submitted to the Inter-American Court a request of an advisory opinion about equality, non-discrimination, and persons deprived of liberty, because we want to have a response about the court on the idea of special policies, meaning to protect LGBTI rights or women specific identities, which should be visible and which should bring their claims and have their rights protected. Now I go to the first question, which is very hard. I'm very passionate about human rights. That's my life. That's the cause that I would say I dedicate my life to human rights. And I do believe, quoting my old friend, Kevin Boyle, he'd say, who are in this field should be with 3 H's: head, heart, and hand. And I do think so. I think it's very important to have all the intellectual approach, to do research, to think. As a professor, I'm always writing, rethinking, doing empirical studies, analytical studies. But I also think it's important to have the experience, to be in the field. In the Commission, we are in the field and all the time, and to be, I'd say, to have the heart. I think it's really a passion. I think we have to find out in our, I'd say, temporary passage to this planet, what makes sense, what my energy will serve to what cause. And my choice was human rights, democracy, and rule of law. I think, as I read the other day, we are not here to save the world, we are here to serve the world. So, what would be our contribution in this field? As a rapporteur for LGBTI rights, I'm very passionate about this issue, about this demand. I do think that everyone should be equal and free, free and equal in rights, dignity, and respect. And the right to be is something that it touches me deeply inside, to be respected by, because you are who you are, not less, not more. But I do think that the first article of the Universal Declaration, I would say that is my response, that everybody should be equal and right in dignity and right. And I'd just like to mention one thing that I read from Cornel West that I really admire, because I do think that we have to have hope. Hope is the force to move our agenda. But I was reading something really beautiful when Cornel West says the difference about optimism and hope. And he says, optimism for me has never been an option, he says, because there is too much suffering in the world. But hope is something else, because hope is not expectatory, it's participatory. Hope is a verb as much as a virtue. Hope is as much a consequence of your action as it is a source of your action. So I'd like to quote Professor Cornel West, because I think it was really beautiful, this view about hope. Thank you.
Thank you, Flavia. I don't see other questions in the Q&A window. So let me ask you the following. You mentioned that you were surprised, if I understood correctly, you were surprised that sanitation was one of the issues that activists, advocates in the United States were bringing before the Commission. And you have done a lot of work in the area of economic, social, and cultural rights. I know that some of my international law students are attending this panel, this conversation, and we were just discussing the issue of social rights and how international bodies, international human rights bodies may be able to, may or may not be able to hold states accountable when it comes to human rights in general, but I'm particularly interested in the context of social rights for a number of reasons. First, because there's this idea that social rights involve, of course, the provision of rights. It involves spending, it involves allocating resources. And so there's a question of how much legitimacy do international human rights bodies have basically to command, to request, to suggest, to recommend states to spend more, or perhaps to spend differently. So in your experience, if you could perhaps reflect on which strategies you think are effective from the perspective of international human rights law to push, to lead, to guide states in being more effective in providing those social rights. And the second issue here, in the specific context of the United States, a country where traditionally there's a view that it's if not hostile, at least skeptical to the idea of social rights, as opposed to many Latin American countries where it seems that many are comfortable at least declaring that social rights should be in the Constitution. It's a different question whether or not those rights are actually guaranteed. So my question is, how do you, as the country rapporteur for the United States, see the discussion, the debate, the ways in which, again, advocates, human rights lawyers, and civil society organizations are pushing the social rights agenda in this country in particular? What strategies they're using, are they being effective, and what could we see in the near future, as especially in the context of COVID-19, where health has become such a salient issue of how we're failing And those who have not access to health are in such a precarious situation compared to those of us who do have health insurance, who can access health services.
Thank you so much for such a fascinating question. I'd like to focus on three main thoughts. The first, concerning our mandate, is inspired by the universality, but as well to the indivisibility and to the integral approach, holistic approach to human rights, and the intersectionality approach, bringing diversity, gender approach, that is very important. So for us, and I think this pandemic brings a very precious lesson. This pandemic, I just published a paper on that, endorses the idea of a holistic conception of human rights. Because you see, now we are here, I could be there, right? That was the original invitation. I will keep this invitation in person. But we are here.
We will host you in Newark.
We will, because I was blocked in my agenda in October. But we are here because our freedom of movement is restricted in the name of health. So look how they link. When we have the protection of health with vaccines, with immunization, then we will have our integral civil rights in terms of freedom of circulation of movement and any other, I'd say, any other dimensions of this. At the same time, we cannot protect the right to health without, for example, access of information. For preventive measures, access to information is key. I do remember as a reporter for Bolivia, the first demand that I received was indigenous peoples asking for prevention campaigns being made using their native languages. So for me, it was a very interesting demand, the first demand. My second reaction is that in terms of social rights protection in the inter-American system, I think we have a history before and after 2017. In 2017, we have a new horizon in terms of jurisprudence with the argument of direct justiciability of social rights. And the argument was Article 26 of the Convention, which provides in a very vague and broad terms social rights, and the progressive implementation of social rights should be read from the light of Article 1 and 2, the first and second, meaning states have legal responsibility, legal duties concerning social rights. I served for 4 years to the working group which was monitoring the Protocol of San Salvador in the OS. We created the indicators. We made the proposal of indicators to provide a more rigorous basis to measure the development, implementation of social rights. So
I'm sorry, I would like just to mention that the protocol, the San Salvador Protocol, for those who may not be familiar, is the additional protocol to the American Convention, which establishes certain social rights, because the American Convention only has one provision on social rights, as you're saying. So this is just to clarify for those who may not be entirely familiar with the American Convention. Sorry.
Yes, wonderful. Thank you so much. Just adding that it was adopted in 1988, almost 20 years after. So this is something to debate as well. How could it be the most unequal region in the world has, would adopt just a kind of civil and political rights instrument with one article devoted to social rights, if we compare to the civil rights treatment, civil and political rights treatments, we have from Article 3 to Article 25, meaning 22 articles. And concerning social rights, just one. But anyhow, then we had this additional protocol in the field, provide right to health, education, labor, culture, food, environmental, And I was part of this group which had the mandate to monitor the implementation of social rights. And then we decided that we need to have a kind of system of indicators to monitor in a more concrete and solid basis the implementation process of social rights. And then we worked with structural indicators and also outcome and process. It was a very enriching experience. So I'd say I would invite all of you to be aware of the jurisprudence of the Inter-American Court from 2007, Lagos del Campo case, and then we had Poblete Vilches, and then we have a number of Cusculpi Varal and other cases which emphasize this voice of the court, that we need to provide protection, judicial protection to social rights. And here I just like to mention, for example, in the right to health, the dialogue between the Inter-American Court and the UN treaty bodies, because then we have global standards which clarified. I'm very rigorous in terms of technical narrative, legal narrative. So if we are thinking about right to health, what does it mean? Which are the components of right to health? And as a consequence, which are the components of the legal duty, the legal state duty to provide and to promote and to protect and to implement, to fulfill right to health. So I think it's really, really important. And for me, I need to learn more. But my impression is that even in terms of cost of rights, now more and more we have this critical view, this critical approach that all human rights have a cost. All human rights involve positive and negative obligations. And we have this minimum core obligation concerning social rights. We have principles like the clause of the progressive implementation, and then we have the prohibition of retrocess and inaction, and we have tools to measure. So things are changing, and I think it's really important to emphasize that equality and freedom and civil rights, civil and political rights, and economic, social, cultural, environmental rights should receive the same treatment, the same emphasis. And just a footnote that we have now, since 2017, a rapporteurship, a special rapporteurship in the Commission devoted to economic, social, cultural, environmental rights. And concerning the US agenda, I just like to say that I'd love to learn more, because in my experience, even I remember my debate with my supervisor at Harvard in 1995 when I was working on my PhD. Until now, I was at Harvard as a visiting scholar in 2018. And I love my supervisor, it's Professor Henry Steiner. And again, we were having lunch and he was resistant to accept the idea that social rights is a human rights. Social rights are human rights as serious and as consistent as civil and political rights. So we have a culture of resistance, but I think we have to change that. And we have to build up our legal narrative, our emancipatory narrative based on universality, indivisibility, and intersectionality, always having as a foundation human dignity. Thank you.
Thank you very much, Flavia. We are past a few minutes, just a couple of minutes. So we would like to thank you again and thank all participants for attending this lecture from the Center for Transnational Law. For students, please sign up for emails, announcements. We will be organizing a career panel in international law soon. So stay tuned. To everyone else, thank you for being here. And again, Flavia, it has been such a pleasure to have you, and we really hope to see you next time in person when we can go back to what used to be life for all of us. Thank you, everyone, and see you soon.
Thank you so much. Once again, my dearest Jorge, thank you so much for this special invitation. And once again, thousands and thousands of apologies. I was the guilty one, but finally we made it, and I'm very happy to enjoy this moment and to debate fascinating ideas in the human rights cause. Thank you so much. My gratitude, my recognition, my enthusiasm, and my admiration to your remarkable and inspired work. Evan, thank you.
Thank you.